Hey gang, Stephen Marshall, KYLandlordlaw.com, back with another update. And today I'm going to talk about some recent guidance that came down from the CDC on their eviction moratorium, as they've given us a little clarity on how things may be done going forward. A joint group consisting of the CDC, the Department of Health and Human Services, HUD, and the Department of Justice issued a response to frequently asked questions about their eviction moratorium. And I didn't see any real surprises in their positions, but I really did appreciate the clarity because their positions are contrary to how some courts are operating. And I'm hopeful that that is about to change. And if you'll go to the blog post that accompanies this video, I'm going to link the FAQs so that you can go through and read them all in their entirety. But they reiterated some of the guidance that I've already given in this space and made it clear that that's the way to go. First, no surprise, they made clear that you do not have to inform your tenants about the CDC regulation or about the declaration form. You don't have to give that to your tenants. Now, I still think that's probably a wise move so that you can figure out your tenant's intentions on signing that form, because your next steps are probably dependent on whether the tenant signs the form or not. Second, the FAQs made clear that you may still file an eviction against any tenant who signs the CDC declaration. That was not necessarily clear at the beginning, but it's clear now. The CDC regulation defines the word evict as any action to actually remove someone, to physically remove them from the premises. So they've made clear in their FAQs that you are allowed to initiate eviction proceedings against a tenant who signs the CDC declaration form. It's just that they may not actually be removed while the CDC regulation remains in place. So you can go ahead and file your eviction case if you want to, even against those who've signed the form, and that will allow you to secure your place in line for whenever the CDC regulation expires or gets overturned. If you do this, you may want to put a partial payment agreement in place during this time period. And you can see my last post for lots more information on that and a form that you can use. And then finally, and this is what was really important, the FAQ stated that the order does not prohibit a landlord from challenging the truthfulness of the tenant's declaration in state or municipal court. Now, this is the issue that's been a source of a lot of confusion and controversy since the CDC regulation took effect on September the 4th. Many eviction judges have been refusing to hold hearings on whether the tenant is telling the truth when they sign the CDC declaration form. This new guidance makes clear that you as a landlord have a right to challenge the tenant's claims on the form. Now, practically speaking, the way that's going to shake down in most cases is that you'll be looking to challenge three areas. First, you're going to be looking to challenge whether your tenant has used best efforts to obtain all government assistance for rent or housing. Okay? All government assistance. Okay? Not some assistance, all available assistance, but it's only government assistance. Okay? They don't have to go around to every church or to every private group who may be offering assistance, but they are required to obtain all available government assistance. So that's one area of potential challenge. The second area is whether they are unable to pay the full rent or make a full housing payment due to substantial loss of household income, loss of hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. Okay, that may be an area that's subject to challenge. And then the third area is whether your tenant is using best efforts to make timely partial payments that are as close to the full payment as their circumstances may permit, taking into account other non-discretionary expenses. So those are the three areas that I think you'll most likely be able to challenge with your tenants. So as you're preparing your eviction case, you'll be looking to put together evidence on those issues. And good facts for you would include that you've informed your tenant of available government assistance and they failed to apply for it. Second, if your tenant has continued to work, in other words, hasn't been laid off, hasn't lost substantial income, that's a good fact for you in being able to challenge their declarations. Third, if your tenant quit their job rather than being laid off due to COVID, that would be a good fact for you in attempting to challenge their declaration. Fourth, if your tenant has not attempted to make partial payments, that would be another good fact for you. If you've got a tenant who has not communicated with you for a long period of time, that would be another good fact. So those are the things that you're looking for in trying to figure out whether you want to challenge your tenant's signing of the declaration. That's not an exhaustive list. There can be a number of other ones, but those are the ones that jump to mind. If you've been following, I recently mentioned a lawsuit that the National Apartment Association joined to have the CDC regulation overturned. The government just filed a written response to a motion in that case. And in attempting to justify their CDC regulation, the government argued two things. They argued, number one, that landlords may initiate eviction proceedings as long as they don't actually remove the tenant. And number two, they argued that the landlord may attempt to show that the tenant has wrongfully claimed protection under the regulation. And again, if you'll go to the blog post, I'll link their entire response so that you can read it if you want to. It's pretty lengthy, but the part that I've cited there is on page 42. So the government, in attempting to justify this eviction moratorium, they're arguing to the court, look, landlords can go ahead and file evictions even when the tenant signs the declaration. And second, they're arguing landlords can even challenge and attempt to show that the tenant doesn't qualify for protections even though they've signed the declaration form. So at this point, in two different spaces, the federal government is taking the position that you can attempt to challenge whether your tenant qualifies for protection. So when the government who issued this eviction moratorium is saying that, I expect that courts will follow suit and allow you to attempt to make those showings in court. So if you have a tenant who doesn't seem to qualify for CDC protections, but goes ahead and signs the form, you're going to want to put evidence together showing that they don't qualify. If you need help with that, reach out to your friendly neighborhood attorney. Everybody have a great week. That's it for today.